I know this is such a great gathering of people. I wish I could have said hello to each of you individually before we got started. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. And I think most of you are probably pretty familiar with ACS, and hopefully you're members of ACS. If you're not, I'm hoping you will join quickly as soon as we conclude the lunch. If you are not familiar with ACS, you should know that we are a nationwide network of lawyers, law professors, law students, policymakers, and judges who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping the debate on vitally important constitutional and legal issues, and our mission is to ensure that the fundamental principles of human dignity, individual rights, and liberties enjoy their central place in American law. Today's lunch would not be possible without our very wonderful hosts, Skadden Arps, and the generous sponsors who've contributed to the lunch today. You can find a complete listing of all those sponsors on the back of the program. So I hope you will join me, please, in thanking the firms and companies and individuals for supporting today's lunch. As we come together on this Constitution Day to reflect upon the values and principles of our governing document, it could not be more fitting to hear from three incredible women who've helped make the promise of equality for all more meaningful for lesbians and gay men and their loved ones. I'm very delighted to start today by introducing our outstanding moderator, Pamela Karlan. Pam is an ACS board member and a distinguished scholar at Stanford. I'm sure I barely need to introduce her to this audience. She is so well beloved by ACS. Pam is also the co-author of a book that ACS published called Keeping Faith with the Constitution. And Pam served on Edie Windsor's legal team in the Supreme Court and is in so many ways an inspiration to all of us. But before we turn to the discussion, it is my great pleasure, along with Pam, to present the Keeping Faith Award to the two women who have helped to lead this long and arduous battle to help advance equality in our country. Edie Windsor and her late wife, Thea Spire, are at the heart of this battle. They were devoted partners for 40 years before they married, and they fought for respect and equality. After Thea passed away in 2007, Edie challenged the Defense of Marriage Act, an ignoble federal law denying same-sex couples basic human dignity. An integral provision of this law was invalidated earlier this year by the Supreme Court in the case bearing Edie's name, U.S. versus Windsor. But of course, as we know in this room full of lawyers, behind every victorious plaintiff is a tireless lawyer. Roberta Kaplan, a partner at Paul Weiss, successfully argued Edie's case before the Supreme Court. Roberta not only helped win victory for equality, she has been recognized as among the 100 most influential lawyers in our country and has garnered numerous awards from organizations that are devoted to achieving genuine equality for all. We simply could not find two people who better embody the spirit and determination required to keep faith with our Constitution. So Pam, would you join me to present this year's Keeping Faith Award to Edie and to Roberta? So please join me in saluting these two amazing women. Leave the box. This is for Edie. Do you want us to bring it to you?
Want to get up?
Yeah.
Yes.
We make house calls. The person forgot to turn on. There we go. We the people. It's an eloquent beginning, but when the document was completed on the 17th of September, 1787, I was not included in We the People. I thought for many years that George Washington and Alexander Hamilton had just made a mistake. But through a process of amendment, interpretation, and court decisions, I've been included in We the People. Those words were Barbara Jordan's at the impeachment hearings on Richard Nixon. But they're true as well for many other groups in America. And when we come to celebrate the Constitution on Constitution Day, it's worth remembering that we the people have, in fact, changed. When I first met Edie last fall, I took a copy of Keeping Faith with the Constitution with me to give to her, and I inscribed it to Edie Windsor in the hopes that she'll be a chapter in the next version of the book. And it's a dream come true that that, in fact, has happened. Most of you probably hadn't heard of Edie Windsor a year and a half ago or 2 years ago. And there's often a myth that the plaintiffs of great cases sort of popped full-blown from Zeus's head. Many of you think of the story, for example, of Rosa Parks, who just one day up and said she wasn't going to move to the back of the bus. But that's a myth. Rosa Parks had been part of a civil rights movement for a generation before she became famous. And that's true of Edie Windsor as well. It wasn't as if at the ripe old age of 80, for the first time, she noticed there was injustice in the world and it was something to fight. So I thought maybe we'd begin our conversation, Edie, with you sort of talking about how you came to the lawsuit.
Wait, also, thank you. It's hard to say. There are a couple of different paths. One was I was indeed, a grassroots activist, and got a Lifetime Achievement Award from SAGE the months before we first filed. Okay, so I had some history with justice and looking for justice and advocating for justice. However, what really happened is I was deeply in love, and I lived with the Aspire for 40-some years at that point, short of 43 altogether. Okay? And I knew that there would be a state tax. Okay? What I didn't know was that even gifts over the 40 years would go back into her estate as far as estate taxes were concerned. So I felt this terrible sense of injustice. And I also, as a little kid, I was the youngest kid in my family, and hence I have a strong feeling about justice. Right? I believed in the Constitution. I don't know if it was 6th grade or 8th grade, okay, where they taught civics for the first time, and I was outraged that somehow, it didn't work for me. And I went around to the gay organizations. There had been a film made about me in a documentary, and so I had that in my hand, and I said, I have a documented marriage. And I need help. And all of the organizations at the time said it's the wrong time for the movement. And I had a friend who was indignant and called friends of his who were in legal placement, who called me and said, would you like us to call some people? We think we know some lawyers who would be interested. Now, as it turned out at the end, okay, I believe that they called a number of people and that Robbie Kaplan walked into my life. As it turned out, but he didn't admit it till the day that the Supreme Court said they would take the case. Okay, we all were having drinks together to celebrate, and he said, I only called one lawyer. Okay. So it was inevitable that we do it. Okay. She, within 10 minutes, 5 minutes, okay, decided she would take the case, and it was go. And we were a perfect combination to do it. First of all, we had enormous respect for smart women, okay? So we respected each other's smarts. Oh, wow. sorry.
All right.
I fidget, though. And then also, I think, you guys talk about strategy and stuff, but I think one thing that happened was my lawyer, an incredibly smart and strong litigator, happened to be in somewhat the same situation. That is to say, she's married to a woman. They have a son. We both had a tremendous amount of our lives involved in it. And I think that helped. But that's,
yeah. And so when Edie came to see you, what happened? How did you find yourself at that place? I mean, so we have this kind of intersection of two people. How did you get to that place?
Well, I'm happy to, as long as you don't have any privilege concerns, I'm happy to tell my version of the story.
okay.
So Edie, I got a call from the person that Edie mentioned, and I knew that Edie lived very close by. She was about 4 blocks away from me. And rather than having a conversation on the phone, I just walked over to her apartment. I think it was the next day. And I walked into her apartment, and it really, she says 10 minutes. It took me about 4 seconds to realize that this was really the perfect case to challenge DOMA. And I don't have to tell you those reasons. You just heard them for yourselves. I took one look at Edie. I heard how articulate she was. I saw how charismatic she was. And then on top of that, it was just extra, is the incredible story, and it really is an extra, it's the core of the case, is the story of her love affair and her life with the Aspire for more than 4 decades. And it immediately occurred to me that given the way they had lived together and given Dia's illness and ultimate paralysis from multiple sclerosis, that was a marriage. Any person in their right mind would want to have a marriage like Edie and Thea had. And so it seemed to me that immediately it was the right case. Edie, though, I'm happy to disclose this today, wasn't sure about me. So she said to me, what are your qualifications to do this case? And there's an Apple computer in her apartment, and I went over and I played on the screen my argument, my losing argument, before the New York Court of Appeals in the right to marry case under the New York Constitution. And we watched a bit of that argument, and she said, okay, that's enough. I'm now convinced. You're hired.
You didn't show her the opinion.
Yes, she did.
I disclosed
Yes, she did. Okay.
I disclosed full disclosure.
Perfectly obvious she was smart as hell. Okay, and we could go with it.
And then Edie said to me, "What's it going to cost? How much is it going to cost?" And I put up my hand and I did this, and that was the negotiation. We had a deal from then on.
So, without revealing too much, how many hours did this case take to bring from beginning to end? Because I think it's a real testament to Paul Weiss, the number of hours you all put in.
I honestly don't know that number. I mean, I don't have it at the tip of my tongue, but it's fair to say a lot of hours. That would be fair. And many of the people on the team are actually here with us today, including Jaren Jarkabani, who put in many, many hours of her own life.
Yeah, I mean, I know at Stanford, just in the just from July 4th of 2012, when we got involved, until the end, we put in something like 600 hours of student time and probably about another 500 of my time. I mean,
I'm not known as being kind of a slack worker,
yeah,
so
yeah.
we work pretty hard.
So when you got the case, did you think there was going to be a trial? Did you think it was going to go off on dispositive motions? How did you make those kinds of decisions?
We didn't know for sure. I think we thought it depended. We knew we were going to file in the Southern District. We knew at the time, and this ended up being very important, that the Second Circuit was one of the few circuits that was open on the question of whether heightened scrutiny should apply to laws like DOMA that treat gay people differently. So those were both good things. We were prepared to do a trial. We thought it would depend largely on who the judge was that we drew. We drew Judge Barbara Jones, who's now retired. And I can tell you that I've spoken to her, and she said she never intended to have a trial in the case. And we thought that once we got her, she would probably do it on the motion papers.
Yeah, and Edie, how much did the course of the trial, the proceedings and everything affect your life in a day-to-day way during the ramp up to Judge Jones's
It did,
decision?
and I try, I try to understand how it did in retrospect, and I don't know, but I was totally involved most of the time. And I read the briefs, I read every draft, okay, and she was wonderful about, correct me, use your head, and I don't know. I was involved most of the time. Most of the time I was involved.
Did you find it disconcerting at all that a huge amount of your private life and your financial life and everything became a kind of open book to the world? Or had you thought about that when you thought about the case?
Not really, okay. I mean, afterwards if things come up, okay, I don't want, they were part of the case. I don't want them discussed generally. But mostly, I don't think so. I got to say, I mean, she really did give me, the opportunity to say, no, that's, unless you can convince me that that's necessary. Okay.
And from your perspective, I mean, most of your clients are corporate clients, and this is an individual client. Did that change the feel of the case for you? I mean, how did this work in with the rest of your?
I'm kind of stretching my mind to think of what the differences were, and I'm frankly not. I'm having a hard time coming up with them. I mean, I tend to treat my clients all the same, and I think we treated Edie very much the same. All my clients would have the kind of say that Edie had over what we do and what our strategy is, and other than the fact that she got involved in my life and we became family in a way that I can't say I have that relationship with all my clients. That was surely different. But in terms of the kind of day-to-day operation, I would say it was pretty much the same. We would send her documents by hand to her apartment the same way we would with the paying client.
And as you thought your way into the case, what did you think the biggest obstacle was going to be?
Well, the world changed so much even from the time we filed the case. We filed the case in early 2010. At the time, I mean, probably the best examples at the time we filed the case, there was no marriage in New York State. It's my fault. I lost the case. Poor Edie had to go. I see Judge Kaye just came into the room. Too bad that Judge Kaye's dissent didn't prevail. Poor Edie had to go to Toronto, thanks to me, to get married. That was, we thought we were very good on that issue in terms of New York recognizing their Canadian marriage. But by the time in the summer of 2011, when New York passed its own marriage statute, that really kind of changed things completely. And there kept being developments like that in the wider world as the case progressed. Some of them, I think, on their own, and some of them, frankly, I think because of Edie's story.
Yeah, so, and one of the other big changes, which you didn't mention, but obviously it played a huge role by the time the case got to the Supreme Court, was at the time that you filed this case, the Department of Justice was still defending DOMA. And I think as a result of filing this case in, as you say, the Second Circuit, which had not yet ruled on the standard of scrutiny, the Department of Justice changed course. Did that surprise you that they did that?
It was the most surprising thing that happened in the case. I was really shocked when it happened. I was on spring break with my family, and we got an email. Well, first of all, let me back up. The Department of Justice asked me for an extension in the case. You people are going to like this. For 30 days, and I didn't want to give it. Edie is not young, and we wanted to get a move on in the case, and I was disinclined to give an extension. And they said to me, Robbie, the Attorney General of the United States is asking you for an extension, and the reason, I said, why? Why do you need the extension? I can't help myself. I'm a Paul Weiss litigator. And they said, well, we're asking for this because we actually are considering what to do in the case. I have to say, sometimes people can be too cynical, and I frankly fall prey to that too often, and I was cynical about it. I didn't believe them. And I said to, it was Tony West at the time, I said, you know what, Tony, when you and the president are making this decision, because he said the president would be involved, I said, I'm going to be praying for you. And that was how the conversation ended. 30 days later, I get an email saying that Tony West would like to have a phone call with you. We knew immediately what it was, obviously, that the president had changed his mind. And there were tears streaming down my face as Tony was explaining what the president had decided to do. And at the end of the call, this was one of my favorite moments in the case, Tony said to me, Rob, you remember when you said to me at the end of our call that you were going to be praying for me and the president? I said, yeah, of course I remember. He said, sometimes prayer works. And that was the end of the call. I mean, interestingly enough, at the time, that was obviously a huge plus for the case. There's no question about it. I don't think any of us, let me back up. Edie and I made a lot of, I think, smart decisions in the case. Certainly the smartest was bringing in Pam Carlin the minute we thought we were going to be anywhere near the Supreme Court to act with us as co-counsel. And when the Supreme Court inserted the jurisdictional issues in the case as a result of what the president had done, I was smart enough to give that entire part of the case to Pam to handle.
Yeah, so it was on July 4th last year. I still remember this. It was July 4th morning. I opened my email to check it before I went out for a bike ride, and there was this email that just said, Dear Professor Carlin, my name is Roberta Kaplan. I'm a partner at Paul Weiss. I have this case. I wonder if you might give me a call about it. So I called her up, and she said, I've got this case. It's a DOMA case. It's heading to the Second Circuit. People tell me that you might be helpful in talking through kind of some questions about if it goes to the Supreme Court. And I said, oh, sure, be glad to. And she said, do you want to be on the team? And I said, yeah, sure, why not? And I wasn't really, thinking quite as much about it at the time. But there was a lot of, this case, in addition to being a major constitutional law case, is a major federal courts case in a way as well. And it's one of the few things you can talk about in a group like this, because everybody's a lawyer, so you don't have to explain it. But you might want to say a little bit about the fact that this was not the only DOMA case out there. There had been a series of DOMA cases filed around the country. And there were 4 of them that were moving forward at roughly the same speed. And I don't know if you want to say anything about kind of where Edie's case was situated in that group and how it ended up being the case the Supreme Court took. Because I think there are a lot of little steps in that process.
Yeah, there were 4 cases ultimately the Supreme Court had before it in order to decide which one it was going to take to hear. And it was a rapidly changing situation during a period of about 2 months in terms of which case the court would take, and in fact, which case the Solicitor General would recommend that the court took. By the end, they were recommending Windsor.
Yeah, we started off in 4th place.
Yeah, we started off at number 4, and we slowly inched our way up to number 1. We now know actually what the reasons are, because after the court decided Windsor, they made their ministerial decisions that they did in the other 3 cases, and we now know that Justice Kagan recused herself from both the Gill case in the First Circuit and the Galinsky case from California. So that pretty much put those 2 cases out of the running. And I think what distinguished our case from the other case, which was Peterson, is that we got a ruling from the Second Circuit, I think in about 4 weeks.
Yeah, I was going to say that one of the things that happened in the case was after we won in the district court, the United States appealed, even though they agreed that we should have won the case. They appealed because the Attorney General took the position that this was really an issue for the Supreme Court ultimately to decide. And so although he wanted to lose in the Supreme Court and not lose in the district court. And so he kept filing appeals because it was unclear if he didn't appeal whether any of these cases would get to the Supreme Court. In the meantime, a wonderfully named entity called BLAG, which sounds kind of like Smirsh or something, right? I mean, it sounds like it's in an Austin Powers movie. But it's the bipartisan legislative advisory group of the House of Representatives, voted by the bipartisan margin of 3-2 to spend millions of dollars of taxpayer money to step in and try and defend DOMA when the administration decided it wouldn't. And so the administration appealed to the Court of Appeals. But we were worried at the time that it would take a long time in the Court of Appeals. And so I think the reason you actually contacted me at that point is you wanted to file a petition for certiorari before judgment, right. Which is a relatively rare way of getting a case. It's essentially a venue transfer from the Court of Appeals to the Supreme Court. Because the Supreme Court has jurisdiction over any case that's in the Court of Appeals, whether the Court of Appeals has ruled yet or not. And so we filed a petition for certiorari before judgment. And that seemed to have goosed the Second Circuit into coming out with an extraordinarily quick opinion. I mean, unbelievably quick, from the time of oral argument to the time of decision. I don't know, Edie, if you want to say a little bit about when you saw the case in the Court of Appeals and you went there, what was your reaction at that point?
Well, I thought it was absolutely wonderful. Okay, I knew that we had 3 judges. One was a Clinton appointee, one was an Obama appointee, and one was a Bush appointee. The Chief Justice was a Bush appointee, and known to be very conservative.
Dennis Jacobs.
And he wrote the most beautiful decision, okay, of any, including the Supreme Court. You know, okay, it was really wonderful, and for the first time, a judge was saying, okay, a case was ending with at least extended scrutiny. You know, certainly not the lowest level of scrutiny.
Yeah, I mean,
Okay.
it was kind of, it was both gratifying and kind of a surprise that he was the only judge who felt, the way I read the opinion, you can both give me your reactions, is he felt he had to go to strict scrutiny because on rationality review, he would have upheld DOMA.
I think he said it was closely argued, were
Yeah.
his words. I agree. We argued that case. I mean, it was interesting. I can date everything in this case by Jewish holidays, pretty much. I argued in the Second Circuit the day after Yom Kippur last year.
And at the Supreme Court on Passover.
Exactly, yeah, just after Passover. And I actually asked the Second Circuit.
Now, here we are, right after Yom Kippur.
Exactly right.
You know, God knows what happens this minute, Sarah.
I asked the circuit if I could change the date because I was concerned. I didn't want. I knew I wasn't going to be able to work the day before, and they actually turned me down, which I thought was a tad rude from the circuit. But I think we now know probably the reason. I think Chief Judge Jacobs was in a rush, and now that I think back on it, it was more than fine with me that that's the way they did it.
Yeah, so the opinion came out of the Second Circuit, and at that point, I think we sprinted from number 4 to number 1 on the list because we had a Court of Appeals decision striking down DOMA in a case in which all 9 justices could sit.
And on the ground that the Department of Justice most preferred.
Yeah, which was heightened scrutiny. And so on the one thing that's a kind of significant date in history that has nothing to do with the Jewish holidays exactly, which was December 7th, the Supreme Court announced that they were going to hear the case. And I don't know if you remember the conversation we all had on the phone that afternoon when you called to tell me they had just granted cert.
Remind me.
You said, we're going to Washington, and I'm going to have a guy give you a blowout like you won't believe.
That's definitely true.
Yeah.
Pam and I had a running debate through the entire case about whether I could let her use my hairdresser. And she joked that when I argued in the Supreme Court, the only woman in the courtroom whose hair was higher than mine was Nancy Pelosi. Although Nancy Pelosi won by a lot.
Nancy Pelosi had high hair, but you remember who had the biggest hair in the courtroom that day?
Gloria Alfred.
Gloria Allred had the biggest hair in the courtroom by an order of magnitude. She is a lawyer from California who is known as a kind of big publicity cause lawyer, and she showed up with hair so big, so vast. Even I was in awe.
I will know that I finally made it as a lawyer. If Pam Carlin ever agrees to use my hairdresser, then I'll know. That'll be it for me.
So the court took the case, but the court, as Robbie said a moment ago, did something else when they took the case, which is they agreed to hear the merits, but then they asked whether there was jurisdiction over the case at all, given that the executive branch was on our side of the case. And they actually appointed a lawyer to argue that there was no jurisdiction. They appointed a true amicus curiae, Vicki Jackson, who's a professor at Harvard. The other thing that, of course, happened that very same day was the Supreme Court took the marriage case from California. And it seemed, looking back on this, that the Supreme Court really moved the two cases around on its calendar until they were lined up so that they could take both cases on the same day. I mean, what was your reaction when you found out the Supreme Court was both going to hear the constitutionality of DOMA question and also hear the question whether states have to recognize the right of same-sex couples to get married?
Well, I was hung up with first of all, when it came to the jurisdiction, which I barely understood, but I kept asking questions. They had scheduled who would be who had half an hour, who had 15 minutes. We had 15 minutes at the end, and then suddenly our 15 minutes disappeared, and I didn't know if that meant they're out, or they're in, and they don't have to argue.
That was one of the worst flights
That
of
was-
my life.
yeah,
Just so
okay,
everyone knows,
okay,
Pam was
and
going to
more.
argue jurisdiction.
Yeah, so I was going to argue jurisdiction, and Robbie was going to argue the merits for Edie, and we were about to come to our first moot here in New York, and I got on the plane in California, and because I'm cheap, I never fly nonstop anywhere. So I landed in Charlotte, and I picked up my phone messages, and it was one person after the next saying, "I'm really sorry. I'm really sorry." Nobody's saying what they were sorry about. And so I called Robbie, and I said, because I hadn't heard from you. I had heard all these other things about, I'm really sorry. And I called Robbie, and she said, "I'm really sorry." And I said, "What happened?" And they said, and they had usually the Supreme Court gives an hour for something. And for our case, they gave an hour for the merits and 50 minutes for the oral argument on the jurisdiction. So they'd just taken our 10 minutes out without giving them to anybody
And
else.
the parties had all agreed on the allocation.
Yeah,
It's not like
and
there
we'd
was
all
any
agreed.
dispute.
So I said, well, I guess I don't have to moot tomorrow, huh? So I got to sit in the audience at the first moot instead. But it was a very odd moment. On the personal side, of course, I was really sad because I wasn't going to get to argue. On the representing your client side, I was kind of, it made me more optimistic they were going to find jurisdiction, because the idea of the Supreme Court saying there's no jurisdiction over Edie Windsor's case, after saying, and we don't even want to hear from her lawyer about why there is jurisdiction, I think that would have been a bad visual. But it was striking, and this is a point that Edie alludes to, that in a case about the rights of gay people, over the course of 2 days of oral argument and 3.5 hours of argument, the first time that somebody gay got up to argue was in the last 15 minutes of the entire time period. Now, some of that is due to Passover, so we must once again blame the Jews.
That's true.
And that is, the Supreme Court announced that it was going to hear the oral arguments, and it set them for the Tuesday and Wednesday of the week of Passover. And Vicki Jackson, who had been appointed to argue as the amicus on lack of jurisdiction, said, "I can't argue on Tuesday," after having accepted the appointment from the court. "I can't argue on Tuesday because I'm throwing a Seder on Monday night." So they switched the order of the arguments in the cases. And that leads to a question I want to ask you, Edie, about your feeling when you got to the oral arguments, which is, the arguments in the California marriage cases occurred on Tuesday, and your argument was occurring on Wednesday. How did you feel after the Tuesday arguments?
I really didn't think they were relevant. Okay.
And that made you feel better, that they weren't relevant.
Right.
Yeah.
Okay. Yeah. Okay. That I felt badly for them. I thought, it had gone badly in some places. I read the newspapers, and Justice Kennedy made some remarks that scared me. I thought, oh God, this turned it off, and it didn't turn it off. The other thing I did want to say, though, about the jurisdictional stuff, we then sat in on someone else's moot court. Can I say that? All right, and as we were leaving, okay, in other words, they had finished the court part, really, and we're just going to discuss. And we were leaving, and the guy running it, can I say who and everything? Anyhow.
I don't know the story, I can't tell you. But.
Shree. Okay, said, if you guys want to add anything. And this one said 5 sentences, which I assumed were the 5 sentences that you would have said if we had had the time to argue jurisdiction. And it was perfectly clear that took care of the whole problem. Okay, it was clear to the guy standing up there needing it, and it was clear to me. Okay, this dummy. Okay.
So, Robbie, I mean, you went to the arguments in the Perry cases. Did it change your approach or change your thinking at all, having seen that argument from what you had planned to do?
No, I actually was feeling pretty good, a little bit differently than Edie, was feeling pretty good after those arguments. I thought it went very well. At one point, not that it was binding in any way, but I think Chuck Cooper conceded that essentially any other statute outside the right to marry that treated gay people differently than straight people would be unconstitutional. I remember I was sitting next to Amy Howe of SCOTUS Blog, and I wrote a note to her and said, did he just say what I think he said? And she said, yes, he did. I was feeling pretty good. We had a meeting back at Paul Weiss in D.C. at about that afternoon, and we all pretty much agreed that the day, at least for us, had gone pretty well, and that we weren't going to change anything. But I think the Perry case, in a way, is a very good lesson that no matter how kind of neurotic and compulsive you are, and I'm definitely guilty of both those things, you can never really fully plan or fully anticipate the way things come out. Because when the court took both of those cases together, I actually was not happy about it. I thought that having the confluence of those two cases at the same time was not a good thing. I was worried that they were asking for too much in Perry and that it would, turn off the court. I think in retrospect, at least for Windsor, it turned out to be a very good thing. I think it made the Windsor case look very much like kind of the logical next step for the court. It made our arguments look like the moderate, easy step for them to take. And I'm not sure that's something I would have anticipated at the time.
Yeah, I mean, one thing I remember from that discussion in the afternoon at Paul Weiss in Washington was one of the questions that, one of the exchanges at the Perry argument had been between Justice Scalia and Ted Olson. And Justice Scalia said, well, when did restricting marriage to same-sex, opposite-sex couples become unconstitutional? Was it in, 1865? Was it in 1791? And we came back to Paul Weiss, and we were thinking about, what our answer to that question was. Because, as you know, Justice Scalia's view of the Constitution is it's not a living document. It is, to quote Justice Scalia, dead, dead, dead. And so we came back, and when we went through that question, I said, well, the answer for us is really easy. It's either in 1996 when they passed DOMA, that's when DOMA became unconstitutional, or in 1791, it was unconstitutional because under the Fifth Amendment, they never would have allowed the federal government to take this power away from the states, which raises a kind of strategic issue that I think we struggled with, and obviously the court struggled with a little bit in the Windsor case, which is the problem with DOMA that it is a violation of equal rights, or is the problem with DOMA that it's the federal government going too far in trenching on state power? And how did you think about negotiating that line?
Well, the short answer is a lot. We spent a lot of time thinking about it, especially because in about the 6 weeks or so before I argued, this federalism argument kind of became very hot, for lack of a better term, in legal circles. And there were a lot of people writing about it. And pretty much every one of the mainstream conservative magazines, George Will, Commentary Magazine, the only holdout was National Review, as I recall. But all the kind of mainstream conservative press at this point was agreeing that DOMA was unconstitutional, but solely on a federalist ground. So we knew this was going to be a big deal. Our argument, which is what the court ultimately did, I think, is to say that the federalist concern, the concern that this was the first time ever that the federal government essentially ignored state determinations about marriage, should raise heightened concern in the court and should cause the court, at a minimum, to look at the statute more carefully. And that's the kind of the line that we drew. The strategic thinking behind a lot of this was that there are probably people in this room who can teach me. I'm not sure exactly where the federalism line should be drawn, and this is what I mean. We can all agree, as I said in the court, that the federal government can't give marriage licenses. That would be, I think, a violation of federalism for people to go to the federal government to get married. So that's easy. On the other hand, I think we can all agree that the federal government can put additional requirements on marriage and not have that violate federalism. Here's the perfect example. When you go down to the city clerk's office in New York to get married, they don't say to you, do you have a real marriage? Do you have a relationship with your husband or wife? Is it a real marriage? You just get the license. In order to get a green card, if one of the spouses is a citizen of another country, you have to actually prove to INS and to the government that it's a real marriage. It wasn't a marriage fraudulently entered into for the purpose of getting the green card. I think we can all agree that that doesn't violate federalism. So the question, I think the really hard question, which I spent a lot of time dancing about in my argument, was where between those two poles the line should be drawn. And the honest answer is I have no idea. But what I did know is I did not want a lot of hypotheticals about that. And so that was really what drove a lot of our strategy.
Yeah, at the press conference, right out on the steps afterwards, one of the things that you said, Edie, that struck me was somebody asked you, how did you feel about the argument? And you said you thought the justices had all been very respectful and very gentle. And that is such a difference over the course, at least, of my career in seeing gay rights cases at the Supreme Court. So just a little background on this. I was clerking the year of Bowers against Hardwick at the Supreme Court. And that year, at the oral arguments, the hypotheticals were all things like, if we allow gay people to have sex in the privacy of their own homes, aren't we going to have people having sex in bathrooms and sex in cars? And of course, the answer to that is people have been having sex in bathrooms and in cars with people of the same sex and people of opposite sex since there have been bathrooms and cars, and nothing that the Supreme Court decides is going to change that. But it was an argument that treated gay people as if they were somehow remarkably different from everyone else. Fast forward to 2003 and the argument in Lawrence against Texas. I was in the courtroom for that. I've been moving closer and closer to counsel table as these cases go along. And I was in the courtroom for that argument. And that time around, much more respectful. There were two questions. There was one hypothetical that was what I call a calling Dr. Freud moment, which is Justice Scalia asked a question about, well, if you're saying this is a fundamental right, what if some people thought there was a fundamental right to sit on flagpoles? What would you say about that? And the whole audience just kind of went, calling Dr. Freud, we have a patient for you here. And then the Chief Justice Rehnquist asked, well, maybe there would be some right for gay people to have their own sex lives, but could they really be kindergarten teachers? This time around, there were no hypotheticals like that at all. And so that was one of the things that struck me is the change. And some of that change, I think, came from the fact that there's different justices, a different generation. But a lot of it came from something that you talked about on the steps. And I wondered if you might say a little bit about that to the folks here today.
I don't know. I know that at the end, my feeling about the decision and that it was indeed, there were still tons of people in D.C. at the time walking around saying, well, states' rights really came through, okay? And I was furious, okay? No, damn it, read it. Equality came through, and equality is what really matters to us.
And what do you think affected the Supreme Court and made them so much more respectable?
Yeah. I think I have to only speculate, okay? But I speculate that as equality began rising in its relative position, they had to change their attitude. Again, I'll go back to I'm a little kid, and boy, I believe in the Constitution, and I believe in equality, and they just realized it, and we're good. We're going to win. And I mean, that's insane, but.
And how did you feel after the argument? I mean, there's this English doesn't have a word for it, but the Germans have this word Steppenwit, which is the things you think of on the stairs as you're leaving that you shoulda, woulda, coulda said. Is there anything you would have changed about what you did with the oral argument in hindsight?
I remember the minute I sat down, I looked at you and I said, I don't think there's anything that would have been different, and I felt pretty good. It was interesting. In retrospect, this didn't occur to me until about 2 weeks, well, even longer than after the argument. And this goes to the point you raised before. None of the conservative justices asked me a single question about any of the rationales for DOMA. I got one incredibly nice softball from Justice Breyer about uniformity, which was such a softball, it took me a second to realize it was a softball. But not one of the conservative justices asked me those questions, and that's really an astounding fact. I think some of it has to do with the weakness of the rationales. I think one of the reasons why they were respectful is because of this woman sitting right here, and it's kind of hard to pick on Edie Windsor in kind of the ways that they had in the past. And I think part of it's obviously how much our society has changed in the intervening years. It's hard for me to come up with something I would have changed. We did a lot of practicing. Pam spent a lot of time beating the absolute you-know-what out of me over and over and over again. So I thought I was pretty much prepared, and I think most of what I said in the argument was stuff that we had practiced and talked about. But at the end, when the Chief Justice started really pushing me on political power, and he said to me, isn't it true that politicians are falling over themselves to support your side of the case? And we really had a debate with each other about what has driven the change. He was taking the position that what has driven this incredible change in our society about gay people is politicians. And people were just following their politicians. And I said, no. And the thought came to me at the time, Justice Kagan had made a point, had done an incredible cross-examination of Paul Clement during his argument about the legislative history of DOMA and of how the astounding fact that the House report on DOMA actually says that the statute's being passed because we morally disapprove of gay people. That's what
that was a stunning moment in the oral argument. She read from the House report and she said, what would you say if they said, the reason we're passing this statute is moral disapproval of homosexuals? And there was this sort of pause, and Paul Clement said, did they say that? And then he said, of course they said that. And then he said, if that's enough to doom the statute, then the statute's unconstitutional.
Which is a plausible reading of the opinion, actually. But the one thing I said that wasn't practiced is as I kind of took that language and I said, no, Mr. Chief Justice, it's the flip of what's in the House report. It's not moral disapproval of gay people. It's an immoral understanding today that gay people and their relationships are no different than anyone else. And right then, the buzzer went off. Yeah. That was about the last thing I got out of my mouth. But very much in keeping with, one of the many things I learned in the case quickly was just to do whatever Pam told me. And one of the things that Pam told me is that this case is really about whether gay people are different than straight people. And if the court can't explain why, and we think it's true, why Edie and Thea's marriage was any different than any straight couple's marriage who's been together for 44 years, then we're going to win the case. And that was our strategy from day one.
Yeah, it was interesting. By the end, the retreat, I think, both in Perry and in Windsor, from any real argument on the other side other than this is the way things have been, let the change come more slowly and everything. And as you said earlier, Edie, when we got the opinion, one of the things that's striking about the opinion, and in this sense it's a little bit like the opinion in Brown against Board of Education, is it is not a doctrinal opinion. We still don't actually know what the standard of scrutiny is. You made the point that Judge Jacobs' opinion, Chief Judge Jacobs' opinion says heightened scrutiny. Justice Kennedy's opinion, it's clear this statute's unconstitutional, and it's clear kind of why it's unconstitutional, which is it's the product of bigotry and a denial of equal dignity. The interesting thing is the word dignity appears again and again and again in the opinion. But it's not a doctrinal opinion. What's your take on that?
Want to go?
No, you can do it. I think I just I thought your argument and your manner of presentation kept moving them. No, seriously. Okay, you were obviously just extremely well, ready to present what's real. And when you refuse to let somebody push you into saying yes or no to something, and then proceeded later to make your point, I do think that did it, My own sense is, I get very mad at you sometimes, but my own sense is no other lawyer could have done that for me.
And I think, and one of the things that is important about the case is the way that it was your case throughout. And that's become increasingly rare at the Supreme Court for a lawyer who handled the actual filing of the complaint to be standing in front of the court. And I think, the fact that you were not a kind of repeat player at the Supreme Court meant you got up there and you were just not afraid. You were not going to back down. You were not going to let the Chief Justice try and push you off into the federalism corner, which is, I think, where he started with you. Really? But when you got the opinion, any surprises in it?
Well, look, you asked me why it's written the way it is, and I can't possibly, I wasn't there and I couldn't tell you. I can, my best guess is that the court, we've already talked about this, given that Perry was up there at the same time, I think they were very, very aware, and Justice Kennedy was very aware of not wanting to prejudge that case. As we can talk about, I think, he will be there when that case comes next, but I don't think you want to prejudge it. And if you start talking about either the levels of scrutiny that should apply or the actual rationales for DOMA, many of which, although not all, many of which overlap in Perry, I think he was worried that if he went there, he'd be prejudging the Perry case. So I suspect that that's why. I think ironically enough, by writing the decision the way he did and talking about gay people having equal dignity 10 times in 26 pages, I think the decision ends up being much broader than it would have been if it was a strict doctrinal opinion, because I think once you've conceded that gay people and their relationships have equal dignity, I think it's all over but the shouting. I think, the next case is pretty much there.
Yeah, that was one of the things that struck me about it as well, is by being a kind of opinion that was about a fundamental principle rather than about doctrine, he has kind of, it's hard to see how somebody who wrote that opinion, if his feet were held to the fire to decide the question of marriage more generally, would find any easy way around that. But it was pretty clear, I think this was the point you were making about they didn't seem so happy the day before. It's pretty clear he didn't want to decide it then, because he said at the oral argument in Perry, can't we just get rid of this case? And Justice Scalia kind of almost leapt across the bench to say to him, we agreed to take this case, we have to decide the case. So the case came down. How's your life been changed by the case?
I have an incredible sense of community, I made a lot of speeches saying why I brought this case and things about in process, but I made a special speech to the gay community and their supporters, and it had to do with the growth of community and of our looking at each other. It didn't. My feelings, yes, it has to do with having influenced the straight world somewhat, but my personal passion had to do with how it influenced us. How we saw each other for the first time, because people were coming out over just the exposure, just the we're okay. Wow. We can get married like anyone else. And there were people who had been married for 5 years who came up to me and said, now I feel married. Now I feel it's real. So there was this burgeoning of our seeing each other for the first time. And it has made for an incredible sense of community. I thought, it's corny, but it's real. I thought if I had to survive Thea, what a great world I live in at the moment. What a great, I feel I have a life full of community and love and joy, and it's all due to all these people. That's all. That's the effect of the case on me.
Plus, you've gotten your refund.
I didn't even care anymore. I had already I moved my car out of the city. I changed the insurance amount. I changed the garage. I didn't have to pay for a garage. I did all the things to reduce my needs for more income. So
you can say that now.
She said, okay. Robbie, stop me. I started to say that somewhere a year in, and she stopped me dead, and she said, you have to have been hurt by the government to sue the government.
Just remember, injury in fact.
And so indeed, I really forgot about the money. It's nice. It's back where it belonged. That's all.
Yeah, this is why I was always nervous when I was sending you the jurisdictional briefs, because the jurisdictional brief said, this is a tax refund case.
Yes,
the government is keeping the money. Do you need to know anything more about why there's jurisdiction?
I would not have fought that. She taught me. That's the only reason you're here. But it's true that it matters enormously to me that everybody is profiting from it.
Yeah, it's kind of ironic. I'm here today for Constitution Day to celebrate with you, and out at Stanford where I teach, Justice Ginsburg is the Constitution Day speaker. So you all should get T-shirts saying, out at Stanford, Justice Ginsburg is speaking, and all I got was this lousy T-shirt.
Exactly.
the dean asked me what question would I ask Justice Ginsburg for some suggestions. And the one I asked, which I'm hoping the dean will get an answer to, and then I can tell you, is when did Justice Ginsburg think up that amazing line about, so what you're talking about here are skim milk marriages?
I actually know the answer to that.
Oh.
Because I have a friend who spoke to her about that about a month ago, and the answer is right there at the moment.
Well, because that line captured, I think, everything about the case, and now thanks to Edie Windsor, we all have full milk marriages. I know some of you will have questions, and so we have a little bit of time for questions. Judge Kay.
I have a question. So I'll start by thanking you, Edie Windsor, for your courage in taking on and continuing this wonderful fight. I'll congratulate you on your choice of the most superb attorney ever.
Okay, now I'm going to get verklempt.
My former law clerk, Robbie Callan, just couldn't have done better. And I'll disagree with Professor Carlin. I think we have the choicest program for the celebration of Constitution Day right here. And I'm so pleased you came to my law firm, too, so it's a little extra special. But my question is, what do you see as next? Surely the issue is not one and over and all. Where do you see as next steps?
I think that my guess is that the very fact that the federal government is now accepting marriages of people who were married in states where they were allowed, but who live in states where they can't get married. I think it makes for an awkward situation for the states that don't have marriage. So I think we have some push in each of those states, okay, for the states to indeed, okay, make marriage equal totally. And I guess that's where it is next, you know, at least certainly for my circle of friends, okay, and the people that I'm working with most of the time, is to make it universal in the country.
I wonder also if there isn't going to be some, what we might think of as backfilling, which is, it seems odd that we've gotten marriage equality from the federal government before we have an anti-discrimination policy in employment or in housing or the like. And so I would imagine that's another area where we'll see some major
I assume
movement.
that it's going to, I don't know how fast, okay, but I believe that will be the movement, okay, toward total equality in all ways, okay. We're not really so strange, and we don't have horns, okay.
Anybody else have questions? Yeah, back there. Yeah, so the question was from Kathy Powell, who's a law professor, and she was asking, what's the next wave of litigation going to look like if Windsor is sort of the Brown of marriage equality?
Now, look, I'm sure most people here know, I mean, cases have been filed practically everywhere at this point. I think there's almost most states that don't allow it, and many of them have marriage cases that were either filed or have been filed recently. Whether that will be the next issue that the court takes and when the court will take it, I think remains to be seen. There's a case, one thing I've learned doing this is there's no way you can control any of this, frankly, no matter how hard you try. There's a case right now in the Ninth Circuit about whether Batson applies to gay people in a civil case. And the Ninth Circuit, I see Judge Kay, I feel like I have to answer her question. I see Judge Kay giving me a look. The Ninth Circuit asked for rebriefing in that case in light of Windsor, and it's a panel that I think clearly probably is likely to hold that Batson does apply to sexual orientation challenges. So that could be a case that goes up. I think it's very hard to predict, but I think that pretty much everyone and their brother at this point rightly feels entitled to bring claims in light of Windsor, and particularly in light of the really broad language in Windsor.
Yeah, and that to kind of build on the question a little bit is one thing that's quite different about gay rights litigation today and civil rights litigation in the wake of Brown, which was the NAACP Legal Defense Fund controlled that litigation. And they could have a strategic plan of which case do we bring next, and because there were no lawyers other than LDF lawyers and volunteers working with them to bring those cases. And one of the differences is the proliferation both of gay rights litigation groups and also private lawyers bringing cases on behalf of individual clients. There's much less control over the timing and the shape of this litigation than there was over the litigation in the period between 1954, say, and 1970. The other thing is that you have a court that is not nearly as favorably inclined overall to equal rights litigation as the court that you had in the period between 1954 and 1969. So it'll be really interesting to see what the court wants to hear and in what order they want to hear it. But much less control and much less shaping of that litigation than was true in the past. Yes?
I don't hear all of you into the backstory a bit. I wanted to ask about the amicus briefing strategy and how that impacted things.
So I made as I said before, Edie and I made a couple very smart decisions in the case. One of them was to bring Pam Carlin in. The other thing that we did the minute the court granted cert in our case is to ask Mary Bonato, who I've called, rightly so, the Thurgood Marshall of the gay civil rights movement, into the case. We were already working together, but I put her in charge of the amicus strategy, and she did an extraordinary job. I mean, I should point out that it's kind of extraordinary. This is a case, Supreme Court case, that was essentially run by women. Pam and Mary and Edie and myself. It was really an extraordinary experience. In terms of the amicus, there were 45 briefs on the other side, 45 briefs on our side. About 98% of the amicus briefs on the other side were all religious briefs, making arguments that recognizing Edie's marriage would violate their religious beliefs in some way, some fashion or another. Our amicus briefs, not surprisingly, were not all religious briefs. We focused on really covering, as you would in any Supreme Court case, covering the areas that we thought need to be covered. We cared a lot about the business brief, and there were 278 major corporations that signed on by the end. They were almost trying to stop the printers because corporations were begging to get onto the brief as it was being printed. The military brief, which was incredibly important to us, and we had a bunch of retired generals talking about how this was inconsistent with military values of equality and dignity, particularly in light of getting rid of Don't Ask, Don't Tell. Those were the two key ones. I have to say I was very keen on the religious brief on our side, which for the first time ever in a gay rights case, one of the religious briefs did not include any gay religious groups. It was all mainstream religious groups, quite intentionally. For the first time ever, we had the entire conservative Jewish movement sign on, including the Jewish Theological Seminary, for the first time ever in its history, signing on to an amicus brief on our side of the case. We had mainstream Presbyterian groups, mainstream Christian groups, and it was important for us, or at least for me, to say to the court, religious people are not only on one side of this case.
Yeah, one other thing about the amicus strategy is originally the idea, there are two kinds of big strategies you can have in a big Supreme Court case about amici. One is the let 1,000 flowers bloom, which is you file a blanket consent with the Supreme Court that says anybody who wants to file on our side, that's fine. That was the position in, for example, Planned Parenthood against Casey, where there were 100 briefs filed and so forth and so on. The other is to try and control it on the theory that if you get too many briefs in there, none of them will get read, or a few of them will get read. And we decided to go with that second strategy, and one of the things that strategy allows you to do is to find out who's filing on the other side, because they need to seek your permission. If you deny permission, the court will still let them file, but they need to seek your permission, and they have to do it in advance so you know whether they're planning to file a brief or not. And that was the strategy we used so that we knew what was coming in on the other side. And do you remember the first request you got for approval to file an amicus brief? It was from the Westboro Baptist Church. And Robbie sent me an email saying, we just got this request from the Westboro Baptist Church. What do I do? I said, say yes, because I thought nothing could be better for us than to have the Westboro Baptist Church filing a brief. And they filed a brief that was really almost illiterate, is putting it kindly. So that our strategy was to let as many crazies file on the other side as possible. And we tried to channel people on our side, but there was such enthusiasm and such kind of pride of place among different groups that although we really only wanted about 20 briefs filed on our side, we ended up with 45. They were all very good. I mean, there were none of them that was problematic, but it was a tension-provoking issue. And of course, somebody from our team had to look at each of these briefs before they got filed just to make sure that we didn't have suggestions for the people who were filing them. But we got great briefs. I mean, just fantastic briefs. And as Robbie said, I think the business briefs, the religious briefs, the briefs from the states, which included a brief signed by several states that did not themselves recognize marriage equality, but said if other states are doing it, the federal government ought to treat those as marriages. I think that was a major achievement as well.
I have to say something. Pam keeps saying we. It's not we who developed the strategy. It's Pam. All the other people in both cases, Perry in our case, gave consent. And so they had no idea. And Pam said, don't give your consent. And I knew whatever Pam tells me to do, I do. So I didn't give my consent. And we had this amazing...
Yeah, we consented to the filing of every last one of the briefs except for two, which I won't tell you about, where we persuaded people not to file the brief ultimately. They wanted to file on our side, but they wanted to make arguments that we thought would be dangerous arguments for us. And so we spent a lot of time persuading people, look, don't file that brief.
And Edie read every single one of them.
Yeah, well, and the way I know this is
I
you
gave
said
myself
to me,
an assignment.
you
Right, I
said
had
to me,
read two
you said to
briefs
me
every night.
something about, the briefs were very heavy, and I couldn't understand why she was saying that until we went back to her apartment, and it turned out it was photocopies of all the briefs, so they were in these
I
huge
know,
binders.
but-
Because I kept thinking, it's like 20 pages.
I kept
you know.
taking briefs out of the book because I couldn't, there's no way I could carry the book.
Yeah, but I hadn't realized that, and I kept thinking, she seems so perky and lively, and yet she finds these 25-page things too heavy. And then I got back to the apartment, and there was like 3,000 pages of briefing. I think we have time for one more question if somebody has one. So don't be bashful. It's not like, no? Okay, well, I know, David, you have some things that you want to say. So David Brodsky, who's a member of the ACS board, has a couple of things he'd like to say.
Before I thank everyone for coming, can we hear a real thank you to this absolutely extraordinary group?
Thank you so much.
That was truly a memorable, spirited discussion, and I want to thank Pam for moderating it. As you no doubt recognize, Pam is formidable. She's a formidable constitutional scholar. She has a formidable wit, and she's a formidable advocate, and she's an amazing friend. Indeed, the Giving Faith Award, which was given to Edie and Robbie, may I call you by your first names?
Absolutely.
Was actually inspired by a book called Keeping Faith with the Constitution that Pam is a co-author of. And now I'm going to sound like late night television. You too may have a copy of this book. All you need to do is, since you're in attendance, you've already satisfied the first requirement, you came to the lunch. But if you contribute $100 to ACS during the month of October, you will not only become a member of ACS, but you'll get this book. And I'm telling you, it's a book worth having, not just on your bookshelf, not just on your nightstand, but in your hands reading. It makes the Constitution come alive. I also wanted to talk briefly about the luncheon. You're getting 1 hour of CLE credit, and if you haven't signed up outside for CLE credit, please do so. Part of the materials that you'll get as a part of being a CLE accredited or luncheon is this copy of the Declaration of Independence and the Constitution, which is on your table. So please take one, carry it around with you. You never know when you're going to have an opportunity to discuss the exact wording of the Second Amendment or the 10th Amendment with a member of the Tea Party in an elevator. So have it with you, and you'll know what to do with it when you get it. Since its founding in 2001, ACS has grown to 40 lawyer chapters around the country and 191 student chapters as of today. We're growing. We have active members in every state of the union, and we have become a really go-to place for progressive thinking about the Constitution and progressive thinking about the way the Constitution affects our daily lives. And there's no better example of that progressive thinking than in Pam and Robbie's work on behalf of their client, Edie Windsor. ACS is able to do this work only because of generous donors like hopefully yourself. So I'm circling back to the late night television pitch, and I hope you will take the opportunity to join ACS if you're not already a member. I want to thank Steve Sussman, who's here. He is the chairman of the fundraising committee of the ACS board. He's a fabulous advocate in his own right, but he's also an extraordinary advocate for ACS. So if you're not talking to me and you're not talking to Pam and you're talking to Steve, you're getting the real deal. He's a real believer in ACS and has been. Thank you, Steve, for your enormous efforts on behalf of ACS. I guess that's all I have to say, except thank you for coming. Thank you to our wonderful panelists. And let's all give a rousing cheer to the Constitution Day 2013. Thank you very much.